Hello, everyone, and welcome to another episode of Legal Tech Corner. Today, we will continue exploring consideration, trying to understand better in which cases considerations are valid and in which cases they are treated as weak consideration and are not enforceable. So, let's firstly start with the public duty. If a person is under public duty, their action cannot be considered as good consideration. So, their duty is not enforceable, and any promise that they are receiving to complete their duty also cannot be enforceable. This principle was established in the case of Collins versus Godfroy, where the police officer was offered extra amount of money to appear as a witness in the court. But since appearing in the court as a witness is their public duty and obligation, the promise of the other party, the extra amount of money could not be enforced and cannot be considered as valid consideration. However, we have cases where the duty exceeds their normal amount. In that case, we can think of consideration that is treated as good and valid enforceable consideration. We can refer to the Glassbrooks versus uh, Glamorgan case, where we had the police guard in their obligation and duty to protect the coal mine during the strike. However, the manager of the mine requested them extra protection, like to have a stronger guard. And that extra protection could be considered as a valid promise, which could be later enforced because it was exceeding their usual amount of duty. Now let's talk about the partial payment of the debts and the cases especially where the creditor agrees to receive the partial payment of the debt as full valid consideration. In that cases, unfortunately, the consideration cannot be enforceable and it is not considered as good. The first time this principle was established was Pinel's case. So imagine payment of 500 euros for covering 1,000 euro debt. In that case, the creditor says, I fully accept the partial payment, but in the eyes of the court, this payment is not enforceable as a valid consideration. And later, if there is a dispute and parties sue each other, then the court will say that the rest of the payment will be still enforceable. There are two other cases which continue to evolve and explore further the partial payment and partial performance of consideration. Firstly, let's start with the Williams versus Rolfree, in which case we talk about construction agreement where we had contractor and subcontractor, and the subcontractor was almost missing the deadline to complete the project, and the contractor decided to offer more money to complete the project and the time. So it means that in this case we have the same amount, the same terms and conditions of the contract, and only the amount of money has increased. There is also an aspect of practical benefit, which the contractor wanted to avoid any consequences connected of missing the deadline. So they decided to offer extra amount of money, and the court brought the principle that the Pinel's case won't work here because we are offering extra amount of money to avoid any consequences of missing the deadline, and we are having here practical benefit. And only in case of practical benefit which is connected with offering more money, we can talk about valid consideration. Otherwise the consideration won't be valid. And we see that in the case regarding Select Move Ltd, where we had similar situation but connected with financial debt, and the creditor agreed to receive the partial payment as full consideration. However, court thought that in case of financial debt scenarios, we cannot have practical benefit. And although the creditor was trying to avoid any consequences of chasing the debtor and wanted to have their practical benefit in cases of financial debt, this won't work and it won't be considered as it wouldn't be treated as good consideration. So now let's talk about the waiver of part of consideration of the right to receive anything from the other party. These scenarios are especially interesting when the other party relies on the waiver of their right. So if there is a reliance on that waiver, then the promise is usually enforceable. We have the case of Hartley versus Hyman, and the case established a principle where if we have an example of lease agreement where one party says that the rent of the October shouldn't be paid and we can continue from November, or when the deadline is extended and you say we don't need the delivery of the website this week, but we need it next week, or you can deliver it next month, or any extension of the deadline is considered as waiver of right of receiving consideration. It means if until the deadline you don't receive a return consideration, you cannot sue the other party for not delivering their consideration because you yourself waived the right of the deadline and you have waived the right of receiving that consideration. So now let's move to the cases where we have variation of the contract. If the contract changes, if there is amendment to the contract, then it is not automatically valid. You need to have agreement of both parties. So an explicit agreement is needed, especially if you think that the notification of one party may be automatical agreement, but there need to be more explicit layer to that. And just agreement of two parties also will not make the contract valid, the new adjustment, because there should be also proportional corresponding consideration, new value, fresh consideration, which will support the agreement with extra amount of money or extra service or any other adjustment which can adequately and sufficiently support the contract. Now let's go back to the Pinels case, where we have the partial payment for the financial debt, and in the cases especially that the creditor agrees to receive that payment. So the agreement itself, the agreement of creditor, does not lead automatically to the point where the full amount of the debt is considered paid only with the half amount of it. The Pinels rule, however, has exceptions. And the first exception is the shift of the position of the creditor. In that case, although the amount of the payment was conducted partially, the payment will be considered as fully discharged. The debt will be considered as fully discharged, and the creditor won't be able to sue the other party for partial payment. Also, we have second exception where goods or services can be provided instead of the full or partial payment. We usually refer to it as horse, hog, or rope. So the third point where what we have is composition of creditors. Imagine group of creditors who decide to reduce the payment and receive partial payment. They totally agree and accept that. In that case, if we're talking of the composition of creditors, we can say that the consideration will be fully enforceable and the creditors won't be able to sue and claim back the rest amount of money. And in these cases, we are only talking if we bring the case to we have a dispute around the case. We are happy with the agreement. If the half of the amount was accepted, then happy agreements are not in the interest zone of the court. Only the disputes will cause this analysis of the exceptions and their implementation. So now let's move to the fourth point, where we have the third party who is ready to pay for the debt. If friends or family decide to partially pay for your debt and the creditor agrees with that, then that partial payment will be considered as fully conducted. And the last point is promissory estoppel. In that case, we have the promise of one party which waives, the creditor waives their right to receive the rest of the payment. So they only accept a part of the payment and they refuse to receive the rest of it. In that case, if the debtor relies on it and spends the rest of amount on something else, there is basically a reliance on that part, then the party, the creditor party, won't be able to sue and reclaim the amount of payment that wasn't been provided. So this was the overall coverage of the consideration, in which cases it is valid, in which cases it is invalid, and what's the variation of the contract, and how it impacts the consideration concept. This is also a good point to view from the perspective of legal tech, because in very complex negotiations, we have many amendments to the contract, many new variations, and the job of the lawyers is to control and ensure that all those amendments are enforceable. And if we think of a contract variation validator tool, which can, for example, go through all the clauses, do comparisons between versions of the contract, and identify all new proposed changes. It can also view whether there are new fresh values as considerations. And doesn't matter what kind of changes happen to the contract. It can be the delivery schedule adjustments or changes in the financial payment structure. All this will direct you into variation of the contract, which needs to have new support, new value, new consideration, which will further sustain the contractual relationship. And it can be an extra amount of money, it can be extra service that can be integrated into the new variation of the contract. So the tool will also be able to provide recommendations on what kind of adjustments needs to be added to proportionally adapt the contract to the new version. It can be extra layer of service commitment or escalating the fees. This is the way how consideration can be viewed, automated, and adapted from the perspective of legal tech. That was it for today's episode. In the next episode, we will concentrate on more aspects of consideration, but with more focus on promissory estoppel. Thanks for watching.